party's extension number, you may dial it now. For Supreme Court and Court of Appeals, press 1. For Court of Criminal Appeals, press 2. Otherwise, please hold the line and you will be connected to a deputy.
Please hold while I transfer your call to that extension. Good afternoon, Appellate Court.
Hi, is James Hivner in? Or Jim Hivner? Hivner?
May I ask who's calling, please?
Jason Cohen.
Okay, do you have a case here?
I do.
What's your case number?
That's a good question. Hold on. It's M2018-00208-C as in cat 0 or OA -R3-CV. He's expecting my call.
Okay, I have not seen him yet this morning, but hold on, let me see if I can find him, okay?
Okay.
Mr. Cohen, do you know what the phone call's regarding?
Do I know what the phone call's regarding?
That's correct.
Yeah, I know. That's why I'm the one calling.
I understand that, but if I can find him, is he going to know what it's related?
Oh, is he gonna know? I thought you said did I know what it's regarding? Yes, he will know what it's regarding. Sorry about that. I misheard
Hold on
you.
just a minute. Let's see if I can find them.
Okay.
Jim Hivner, can I help you?
Hi, how are you? Jim, it's Jason Cohen calling.
Mr. Cohen, how are you doing?
I'm all right. How you doing?
I'm fine, thank you. How can I help you?
I'm just trying to get my case heard by the appeals court. I think a situation you're missing is the court, like the lower court, is just not accepting like anything that I send. So even like if I would have changed what I wrote, yeah.
Have you filed a transcript?
Have I filed a transcript?
Yes, sir. Have you filed a transcript with the court? I think what you said was there were no proceedings at the court.
Right.
Right?
Yes.
So if there were no proceedings, then there's no reason to file a transcript.
Right.
I'm assuming you had no hearings.
There was one hearing, and there was one transcript from that hearing.
Was there a court reporter there?
There was.
And was that filed?
Actually, I'm not sure if it was filed. I can look on the record. That's a good.
Did you file it?
I didn't file it. It was actually the court reporter was I guess put there by the plaintiff. But actually, like it's pretty it ended up ultimately was pretty incriminating towards him. But yeah, there was one hearing that so the case and
Do you want that transcript filed?
Yeah, absolutely.
Well, okay. Then I guess here's what you need to do. You either, if that's the only transcript and that was the only hearing, then you need to either see if that was filed. If it was, then you've got nothing to do. If it wasn't, then you either need to obtain the transcript from the court reporter, get a copy of it. They'll charge you for it, obviously. Or you can, like I said in my email, file a statement of the evidence if you want to do that. Or you can just file a statement that there will be no transcript filed.
Okay, so I think what I filed with them was a statement of the evidence that I compiled, which included that first hearing. So the transcript from that hearing is included on the website I created, claudiabonnyman.com, which included that first hearing transcript as well as emails and recorded calls of Julie Spencer, who's her assistant, and of Claudia Bonnyman herself. And all of that evidence, nothing that I put on this website was hearsay. It's all evidence from either email exchanges between me and the attorney, or direct phone conversations with the court, or that one first hearing. And I did file that. I think in accordance with 24D, which is the statement of the evidence, right? Or I think I put it at the top. Hold on, let me check real quick. I spent a good amount of time sort of researching the difference between those two. Let me see really quickly what I titled it. Are you there? Hello?
You have reached the Tennessee Appellate Courts. Our office hours are 8 a.m. to 4:30.
Please hold while I transfer your call to that extension. Good morning, Appellate Court Clerk's Office.
Hi, I was on the phone with James Hivner. My phone call got dropped.
Okay. Let me see if I can find where he is. Hold on just a moment. What is your name?
Jason Cohen.
Okay, hold on just Mr. Cohen. Just one moment. Are you there?
I'm here.
Mr. Cohen?
Yes.
Okay, hold on.
Yeah.
This is Jim Hivner.
Hi, sorry about that. My cell phone service has been kind of spotty. This is Jason Cohen.
Yeah, no problem. I understand that happens to everybody.
Hey, sorry about that. So yeah, like
So you had said that you thought that you filed a statement of the evidence, and I was asking why you thought that. Did you call it a statement of the evidence when you filed it?
yes. So
Whatever it is that you're talking
I
about.
said pursuant to Tennessee Rules of Appellate Procedure 24E, the defendant Jason Cohen
Yes, sir.
requests that the record be amended to include truthful, factual, indisputable evidence and information available at www.claudiabonnyman.com.
Well, that's not a statement of the evidence, Mr. Cohen. A statement of the evidence is a statement as to what happened in a court hearing. It's a recitation of what the proceedings were in the court hearing. It's like a transcript.
I understand, but my question is this, and I understand what you're saying with that, but is that provided to the appellate committee or these judges like exhaustively, or is that in addition to other evidence that I can provide?
Well, okay, Mr. Cohen, here's the way the appellate court works, okay? And first of all, we probably just need to address getting your case from being dismissed. So, but the way the appellate court works is when you file your notice of appeal, then you have 60 days to file a transcript with the court, okay, of what occurred in court hearings, okay?
Right.
You don't have to file a transcript. If you don't have to, you can file, if you're not able to, you can file what's called a statement of the evidence, which is what I tried to point out to you in my email.
Right.
So, and that's the same thing essentially as a transcript, except it's your recollection because there's no court report or transcript. Okay?
Understood.
You don't have to file either one of those. You can file a statement that there is no transcript.
So
after you've done that, then what happens is the clerk compiles all of the paperwork that has been filed in the clerk's office, okay, and they send that to the appellate court. Whatever has been filed at the clerk's office and was before the trial judge, I'm not sure if your case was dismissed or what happened to your case.
It wasn't. I was
used by the trial court judge to resolve your case.
Right.
Is what goes before the appellate court. Nothing else.
I understand.
Only what was before the trial judge.
Okay, so and that's where my whole massive corruption thing happened. A lot of what's on the record, or like the vast majority, I would say 98% of what took place in our exchanges and communication happened outside of that first hearing.
Yes.
Okay. So if I just said a statement of the evidence, like my recollection.
There wasn't another hearing, though, right?
There was not another hearing. However, there was a lot of communication. Like
there were
okay, so
communication between whom?
So for instance, like since I was out of state, so there were times where they vacillated, where like they expected me at first, like they knew I was an out-of-state litigant, and they only acknowledged like the jurisdiction thing in her final order, which was pretty messed up. But so I guess they expected.
Who was that?
Chancellor Claudia Bonnyman. I didn't even know the word jurisdiction until the very end, and I was like, wow, she didn't even have the authority to be presiding over this. What I'm saying is, like, we had, for instance, outside of a court hearing, we had communications by phone where myself, Claudia Bonnyman, and Bill Jakes, who's Douglas Fisher's attorney, had like lengthy phone calls, like hour-long phone calls, which I guess in some. Pardon? Yeah, those the not the first one, the before that happened prior when I was trying to get my they filed a temporary injunction, but the second one was, and I was the one that recorded it.
Was there a court reporter there?
Well, no, because it was on phone. I was in a different country when it happened.
So those were essentially, and maybe I'm not sure, but those were essentially court hearings by phone.
I guess so. Yeah, I would assume so. Yeah.
Okay. So, I mean, you can do a statement of the evidence for those hearings if you desire to. I mean, assuming that but regardless.
Would those be considered less like, so for instance, it's not quite a statement. It's not like binary. It's not either like a statement of the evidence or a transcript. Mine is sort of a hybrid of the two because both exist. And basically, essentially,
I'm not sure what you mean by that. A transcript is a written document.
Which one exists, and then also a statement of the evidence because there is a lot of evidence that was purposely left out of the official record. Like our first call, our second call.
Those aren't in the official record until you make them part of the official record.
So that's why I tried to do that with what I.
Transcript.
Okay.
To make them part of the official record.
So that's what I requested. That's why I said.
There were hearings, when you say you request it, you can't request it. You're the one that has to do it.
So that's what I did. I said.
The trial court clerk can't do it. If you want a transcript, you either have to have a court reporter transcribe it, or you have to transcribe it. If you want a statement of the evidence, you have to prepare it. The clerk can't do it. And I think that's where you're getting confused. The trial court clerk can't just come up with what was on the phone call.
So what I did, and I made it publicly available at the domain claudiabonnyman.com.
That was not the conversation. claudiabonnyman.com was not the conversation that you had on the phone.
No, but
I think you're missing the point.
No, I don't think you understand. What I'm trying to say is claudiabonnyman.com is simply a domain name, which I used to host evidence from this case. So a PDF.
Okay.
of the hearing transcript is available there.
You can't just, well, you have to file it. You can't just reference
So
ClaudiaBonnyman.com.
Okay, so how do...
And you have to call it a statement of the evidence. That way the other side can respond to it.
Okay. Who do I file it with?
The trial court clerk.
Okay, but I'm accusing them of corruption, so I don't think they're the best people.
I understand that, but that's a different issue. You still have to file it there. They're going to file it for you. If you file a statement of the evidence, they're going to file it.
Let me ask you a question.
And you have to serve it on the other side. The other side has a right to respond to it.
Sure. So let's say for instance, like they are corrupt, right? And I have served this on the other side. The other side is corrupt. Is it possible, since they've made bad decisions?
I understand everybody in this case is corrupt, in your opinion, but it doesn't change the process.
Okay, so what I mean, it's quite simple. What do you want me to ask them to, what do I need to say? Do I need to say everything? And that is, everything on ClaudiaBonnyman.com is not hearsay.
No, Mr. Cohen, I think you're missing the point.
Okay.
Okay, think of it this way, okay? Let's assume you had a court hearing, okay? And in the court hearing, you speak, the attorney for the other side speaks,
sure.
The judge speaks.
Okay.
When you have a court reporter there, that court reporter types all that information down. What everybody is saying gets typed down, okay?
Okay.
Are you with me?
I got it.
And then after all that hearing is done, the court reporter goes back to her office and she types on a written piece of paper everything that everybody said.
Okay.
Okay? That's a transcript.
Okay.
You understand that?
Yeah.
Okay. So once the court reporter does that, you can file that written document that we call a transcript with the court. Okay? Now, if there wasn't a court reporter at the hearing, all right, and let's say, for example, that you recorded it.
Okay.
Okay? You could type it all down in your computer and print it out, and there would be a transcript of what you said and what the attorney said, and it would be in order. So if you said something first, and then the attorney said something, and then the judge said something, it would be all in order. Okay? Just like it happened at the hearing.
I understand.
You could do it that way.
Okay.
Let's assume you don't have the recording. Okay? Let's assume there's no court reporter and you don't have a recording.
Okay.
All right? You were at the hearing. You know what was presented. Okay? Or at least you have your recollection of what you said, and what the other side said, and what the judge said. Okay?
Right.
You can type that all up from your recollection.
Okay.
And you can say, this is what happened during the hearing. Okay? That is a statement of the evidence.
Okay.
Then you file that with the trial court clerk. And then somebody can look at that one document, whether it's 1 page or 50 pages, and they can read it. They don't have to go to the website and look at it. They can read exactly what it is that was happened during that hearing.
I understand. So, but my point is that they're
Does
not.
that make sense?
It does make sense, but the whole point is they're not accepting anything
You
from
haven't
me.
done that. You haven't done that.
Well, not that specifically, but I filed other stuff that they've ignored. So what I'm saying is, like, I can't get them to take anything. They didn't take my last one and say, okay, this was, like,
Well, if you,
for instance, like, let's say there was some evidence.
do that first.
Well, hold on.
So that you prepare a statement of the evidence.
Let me say something.
You attempt to file it.
Let me say something.
Let me finish my sentence first.
Okay.
And then you can speak, okay?
Okay.
We can't speak over each other. So, what you need to do is, if you're going to file a statement of the evidence, which you don't have to do, I'm not telling you to do that. You can file a document that says I'm not going to file anything. But if you're going to prepare a statement of the evidence, you need to do it and then attempt to file it. And if they refuse to file it at that point, that's a whole different issue, okay?
Well, yeah, that's the last thing that. Yeah, that's.
You can't really complain about that because you haven't attempted to do that yet.
Okay. So you're talking about one hearing that you want transcribed. I get that. What I'm trying to say is, like, what?
No, I'm not talking about anything. I'm saying I don't know what happened. If there was a hearing and you want it transcribed, or if you want to file a statement of the evidence about it, you can do that. I'm just telling you the process for doing it. I don't know how many hearings there were. I don't know if there was 1 or 25. I really don't know, and I don't really care, to be honest with you. That's up to you to decide. And if there was,
So
I'm
what
telling
if
you the
what if what
process
if I need to submit
for getting
evidence?
that before the court.
I understand, but what if I need to submit evidence that is unable to be transcribed, like a photo, for instance, or like a video?
Was it submitted at the court?
Well, here's the thing. It hasn't been able to because after that recorded call,
Well,
that
then if it wasn't submitted at the court, then you can't. It wasn't part of the evidence.
because it's called obstruction of justice.
It may be that
What I'm
the
saying is
court
they stopped.
refused to do it, and you put that in your statement of the evidence.
Once again,
You can say in your statement of the evidence, I attempted to present a photograph, and the court refused to hear it. You
okay,
can put that in your statement of the evidence,
So-
but you can't put the photo in there because the photo wasn't presented.
okay. It was though.
Does that make sense?
Not really, because there was many things that were presented that they just chose to ignore, like my counterclaim, for instance, which is on file on record with
Your
a jury.
counterclaim is on file.
Yeah, with
The
a jury
fact that
demand.
the court didn't do anything with it, that's what the appeal is about.
Okay.
That's not part of the statement of the evidence.
So if I make a statement of the evidence and I say I want everything included that's relevant and factual on.
No, you're not saying I want everything included. You're saying what is happened. This is what happened. This is what happened during the hearing. You're not telling anybody I want you to include something. You're saying this is what happened.
What I'm trying to say is the evidence.
Does that make sense?
Yeah, but it's the evidence is richer in its original form than having it transcribed. Like you have video or audio
It
recording.
doesn't
or
really
something.
matter. You don't have it in its original form.
I do have it. I have the audio recordings. So if you want, I can submit.
You have the audio recordings of the hearings?
Yeah.
Okay, then you have to transcribe them.
Okay, and then
if you want those to be part of the court record.
Okay. And then what about photographic evidence that are part of the record? They're in the counterclaim. So my counterclaim that was filed, right? Will that be part of the court record?
Your counterclaim, yes, it's part of the court record already.
Okay, so
everything that you've already filed with the clerk's office is part of the record.
Well, that's enough. We don't even need the last recorded call. How do I just get them to send what they have? I already asked them for it.
File a notice that you're not going to file a transcript.
File a notice of no transcript?
Yes, sir.
If it's a transcript that's already been on file with the court, I don't need. So a notice of no transcript means there's no additional transcripts?
Well, no. Yes. So if there's a transcript, and you weren't even sure if that transcript was on file. So if that transcript's on file, file a notice that.
Do you get what I'm saying? I think we're miscommunicating. Is the notice of no transcript additional transcript? Because I'm pretty sure the first hearing transcript is on file.
Okay, well if it is, then I would just file a notice that says there will be no additional transcripts.
I mean, the reality is this is I can't even look at what's on file. It's it's only for lawyers, which is kind of.
Call the clerk's office and ask them.
Okay. Hold on one second. I'll look for it right now. But so basically, the notice of no transcript is for no additional transcript. I'm fine with what's on record now. And with what's on record now, any appellate court that's not biased would say, yeah, this is nonsense. But okay.
Well, I don't know. I don't know anything about your case. I'm just saying, from a procedural standpoint, the trial court clerk has said there is no transcript that's been filed. Okay, I would call the trial court clerk and verify that there is a transcript, and if there is, just file a notice that says there will be no additional transcripts, and I want you to send that transcript up.
Okay, can I send it to you directly?
No. You have to file it to the trial court clerk, not to me.
Okay. Let's see. Very odd. Is it possible that they I actually took some screenshots of the record early on. Is it possible they amended the record different times, or that doesn't usually happen? Well, not my case is completely different, but
I don't
yeah.
know what you mean by amended. I mean, it gets modified daily every time anybody files something.
But can they go back and delete something?
If it was wrong.
Okay. Yeah, I definitely remember the hearing was originally filed. Let's see, order setting hearing, order issued, there's some subpoenas, affidavit, notice of hearing, motion hearing, motion of, let's Let's see. I don't even think
So,
the hearing is
you
on
understand what you
here.
need to do at this point?
Well, not really, but hold on one second.
Really, I don't have the time to just sit here and listen to you go through the court record.
I mean, hold on, just give me 1 second. It's not the whole record. It's not that long. Affidavit. I think they changed it, which is odd, but thank God I took some screenshots, so it'll show that they tried to delete some of the evidence. I knew they were going to do that. Okay. So yeah, there was an initial hearing, and that actually I have a copy of that. So I just file it with the court and say, okay, but here's the issue. They're not taking anything that I file. So how can I ensure that they're going to accept it?
Well, if you and they refuse to file it, then you can file something with our court advising us of that.
Yeah,
But
like, can I do that? Look, I've attempted.
No, I don't want to hear about everything that's already happened. I'm just telling you to go ahead.
I have
and do
attempted
it
to
now.
file many things with them. I would really like to move forward to the.
I'm just talking about this
Okay.
right now. I'm trying to get you to the point that your case doesn't get dismissed, Mr. Cohen. Then you can deal with all the other issues with the Court of Appeals.
Okay. So you want me and I'm not. You're not. Okay. Let me just clarify. I have tried to file something that was titled TRAP 24E, right? In what instance would that be utilized? When you want the record modified, correct?
When you want to supplement the record, but at this point you don't even have a record.
I do have a record. It's like what took place. So I do want to supplement the record.
When TRAP 24E is discussing when a record is filed with my office, and then you've reviewed it and you say, you know what, it doesn't include everything that happened at the trial court. Then you would say, I would like to supplement or modify the record. Does that make sense?
Yeah, sure. So
first there has to be a record in my office. Right now there's no record in my office because you haven't complied with Rule 24B, C, or D.
Okay, so you want me to get the transcript from our first hearing and file it with the court clerk?
I'm not telling you I want you to do. If that's what you want to do,
I would, yes, I would like to include that. But if they will not accept it, what do I do at that point? Like even that first part, not before the other side can oppose it. If they will not accept me filing that transcript, what am I supposed to do at that point?
Then you can file a motion with our court advising the court that you attempted to file the transcript and you refused. It was refused, and you can ask the court to require the appellate court to accept it.
Ask the appellate court to require.
But I wouldn't worry about that until it happens. But anyway, that's what you would do. That's what you would do.
Okay, so
if they refuse to accept your filing of the transcript,
amongst other things. So what is the process for filing a motion with the appellate court?
You would just send it. You'd prepare it and send it to the appellate court. You'd mail it.
Okay, is mail the only way that you guys accept things?
Yes.
Okay. If I'm out of the...
Well, I mean, you can send it FedEx or UPS or...
Is there any digital format that you accept it in?
No.
Okay.
Well, fax. Yes, fax.
Can I fax it to you?
If it's a motion...
It's a motion?
You need to look at the rules. If it's a motion that complies with the rules, yes.
Okay. So with this motion that we discussed, saying that they're not, listening to my motions because of, some fax filing fee that falls outside of civil procedure, would that be a motion that I could fax file to you?
I didn't understand what you said. I mean, if you're saying you attempt to file the transcript and they refuse to allow you to file the transcript, then hold on a second.
Yeah, I would like to initiate that right now. I would like to tell the appellate court that yes, I would like for the exhaustive.
We haven't done it yet. You can't
I have. Even if it was
You've tried to file the transcript. You just told me we spent 30 minutes talking about this, and you told me you have not done that.
That's one document from one hearing.
Said somebody else filed it.
Okay, this is what I said.
That's all we're talking about.
Okay, but
that's all we're talking about.
Hold on a second. Hold on a second.
Hearing.
Fine, but what I'm talking about is greater than that. The document that I filed was notice.
Well, I'm not talking about what's greater than that. I'm talking about this.
Just, can I finish what I'm saying,
please? The only thing I care to talk about.
Can I finish what I'm saying, please? All I wrote was notice defendant requests court record, the entire record be furnished to the Court of Appeals and be amended to include relevant factual evidence contained at www.claudiabonnyman.com. I said the entire court record. That's all I asked. I asked the lower court to furnish the entire record that they have and give it to you.
That's got nothing to do with this.
The court record has nothing to do with my case?
That's got nothing to do with what we're discussing. We're discussing Rule 24 and your compliance with filing a transcript.
Okay, so just because there's like...
We're not talking about the rest of the record.
I understand, but I'm trying to get this straight.
If you want to deal with that,
you
need to deal with that separately, okay?
Okay.
I'm trying to address this one issue, which is what you emailed me about. And if you don't want to address that, that's fine.
Fine. But what I'm just trying to clarify is...
something else. I'm trying to deal with one simple issue.
Okay, so what I'm trying to understand is, are you trying to collect the evidence of what took place during the trial piecemeal, like one transcript here, one motion here?
It all comes up at one time, Mr. Cohen. It all comes up at one time from the trial court clerk.
So is the transcript?
I don't know what took place.
Is the transcript different from the record? Or the transcript is part of the record?
No, I mean, it's part of the record.
So that's what I said. I filed a document requesting the record.
But it's not part of the record until you get it filed.
So I don't want it. I don't even need it in there. I just want the record. I don't. But what I'm saying.
Then fine. Then you need to file a notice saying I don't want it in there.
But
I haven't done that yet.
Okay. So I said.
And then once you've done that,
wait.
The trial court clerk will compile the record. Okay, and they'll send the record to us.
Okay, I understand what you're saying. I will
They won't
go.
send it to us until you've done this.
What is?
Do you understand that?
I understand. What is? So the trial court has told you that there is no transcript on file?
The trial court clerk has said you have not complied with Rule 24. That's correct.
So if there has been a time previously when that hearing transcript has already been forwarded and I can provide evidence of that, what do we do in that instance?
You need to call the trial court clerk, talk to them about that, see if that's correct, and say that is the transcript. Or you can file a notice that that is the only transcript that you want sent up.
Can I file a transcript and a statement of evidence?
If you feel it's necessary, yes.
Okay.
I mean, I don't know. I mean, you may have a transcript for one hearing and a statement of evidence for others. Please don't.
I understand. I understand. So the point I'm trying to make is this, and just quite simply, is I filed one document, for the benefit of efficiency that just says I want the entire case record sent to you guys.
Yes, sir.
So did they comply with that part? So all I have to do additionally is...
They can't send us the record until you comply with Rule 25. I've said this 10 times.
It just, I get...
I'm not really sure why I need to continue to say it. Until you comply with the rule,
because they can't
send a record.
It just seems illogical. It's like they need to send one little piece of the pie before they send the whole pie over.
I understand you don't think it's logical, but it's irrelevant whether it's logical or not. That is the process.
I'm sure taxpayers would find that.
So if you don't want to comply with the rule, that's fine.
No, I do. I'm just saying it just seems very inefficient. I've asked for the entire record, and you're saying, okay, until the transcript, like one piece of the record is sent, the whole rest of the record can't follow. It just seems like redundant.
No, you're misunderstanding. You're misunderstanding. Until you assure that there is a transcript at the trial court clerk's office, or you say there's not going to be one, they don't know what to send up.
How about whatever?
They want to send everything at one time.
Okay.
But you haven't filed a transcript yet.
So I don't need a transcript. I just said send the record.
Then you need to send a notice saying I'm not filing a transcript. I've said that 10 times to you.
But I did.
File a notice saying I don't want a transcript. You didn't.
Well, there was.
Show me that document. Email that document to me. That document that says, here, Trial court clerk, I will not be filing a transcript.
I will not
Send me
be
that
filing
document,
additional
and I'll agree with
transcripts. Okay. Okay.
Send me that document. Send me that document that you've already filed.
I understand. I'm going to. Can I?
No, you don't understand.
Okay. Can I fax file it to them today?
I don't see why not.
Okay, but they're not accepting my fax filings, and I'm out of the country right now.
Well, it'll be probably because you haven't paid their fax filing, so you probably just need to mail it to them today then.
I can't mail when I'm out of the country. So, like, let me get this straight. I could be involved in a situation.
You can use FedEx.
Certain.
FedEx works everywhere.
Yeah, kind of.
I don't know what country you're in.
Okay. But let me ask you a question.
I've been in a lot of different countries, and they work. FedEx goes lots of different places.
Fantastic. So let me ask you a question, and this is just like a side note. As a defendant who could have been pulled into something that was complete BS, like it's like Tennessee court's expectations that I have to pay to like proceed in something which could be a situation of malicious prosecution.
I'm sorry, say this again.
It's Tennessee's expectation that as a defendant, something I could have been pulled into a case of malicious prosecution, totally bogus, that I have to pay to just be involved in something that I did not initiate. That seems absurd.
No, well, I think what you're talking about paying are fax filing fees.
Yeah, either fax filing
If you're
fees.
going to fax file things, if you're going to fax file things, you have to comply with the rules. You don't have to fax file. There's no requirement that you fax file. So if you're going to fax file, there's a payment requirement.
Yeah, they don't. I've tried, and that's like another thing also. I've tried paying the fax filing fee. They don't accept payments over the phone. You have to go in person.
I can't imagine that they won't let you send them a check.
Yeah, maybe. But either way, why is this? Why? Like my whole thing is like I'm just scratching my head as a taxpayer. Why is this so hard? Like it should be so much easier. In the 30 minutes.
What is hard?
Like the fact that like for instance like I can't fax something to them until I pay them a fee, or that when I requested the entire
You haven't paid them in court because you owe them I think $262 or something like that.
And you know nothing about my case, but you know how much I owe with the fax filing fee?
I only know that because it's in the notice that they sent us.
But you know nothing else about my case. Sir, you guys are all so full of shit, it's unbelievable. You are so full of shit, it is unbelievable. You should be ashamed of yourself. You're obstructing justice.
I know what was filed in my court. I don't know what's filed at the trial court.
But you know the exact balance of how much I owe on the fax filing fee? Give me a break, man.
It was filed at my court. It was filed at my court.
Okay, so if you,
I know what was filed in the
effort of seeking justice, not because like hiding bad behavior behind civil procedure, oh, we can't do this, we can't do that. Let me ask you a question. When a tenant resides in Nashville, isn't there supposed to be 2 weeks statutorily before a warning before any sort of legal action is carried out?
I have no idea.
You're an attorney and you're the head court clerk of the appellate clerk and you have no idea?
I have no idea. You know, I don't do tenant law. And you know how many laws there are in this country?
Well, I'm talking locally. I'm talking in Nashville. I'm talking in Tennessee, statewide.
Mr. Cohen, I don't have time to deal with this. I've tried to explain to you what you need to do.
No, you're trying to get me to jump through hoops just to make it even increasingly burdensome.
I'm trying to explain to you what the process is. If you want to follow the process, then go ahead. If you don't, that's up to you.
Listen to me. I filed hello? What a fucking dick.